to those submissions, and in answer, principally, the submissions filed on behalf of Mr. Chavdio. We say as follows. The following points are raised. One, that our application is premature. But that this court lacks jurisdiction for a number of reasons. One, that no rules haven't been made to facilitate the action. The court has no jurisdiction. Two, that what is before you is in substance which, as your Honor knows, is governed by Article 163. Your Honor, if I might address the prematurity first. The jurisdiction of the court is set out in clear and unambiguous terms in section 77, subsection 4 of the Constitution, which provides, Your Honor, that the Court of Appeal shall have exclusive jurisdiction to hear and determine any question as to the validity of an election of insofar as that question depends upon the qualification of any person for election or the interpretation of this Constitution. This court, in a previous case, you see, Your Honor, do you have the case before you? It should have been filed with our submission. UC, re-UC, Quayana, 19. Okay. Now, since time quickly to, it says page 134. It's at the bottom of 134. That's just below letter G. Justice. This is just Japan states that this court, by Article 177.4, this court must be limited to those issues that are specified in Article 177.4. Be properly dealt with are the qualification of the president, that's one, and which is disjunctive, or the interpretation of the Constitution. Now, we say that what is before you principally a question of the interpretation of the Constitution. And Your Honor, can you hear me? The video.
Somebody's talking.
I think someone else is. Your Honor, through you, might I just ask you to allow us to speak with closed mics? I believe that that has an effect. Having done one or two of these tracks, if the mics are open, then that affects the quality of the vote. So the question which we move this court to decide does not rest principally or at all on the proximity or lack thereof of the president. The condition that a president is elected is what gives us legs. What we ask your honors to do is to interpret the Constitution to determine set out in our submissions whether certain words in the Constitution, in particular more votes cast, and the law, be construed as more valid votes cast. Your Honor, point. So I've dealt with prematurity. Learned friends say we are premature, we say no. We are squares within the enabling provisions of Section 177(4). On the question of jurisdiction, learned friends argue that, as I said in my opening, the court lacks jurisdiction. And this of course is by way of to their prematurity argument. The court lacks jurisdiction because no rules have been made to facilitate the exercise of the power that we ask you to exercise. Now, if you look at this section, again, I'm carrying you back to the article. Your 177(4) and 5 provides that subject to the provisions of this Constitution, Parliament made provisions for giving effect to the provisions of this title. Learned friends have pointed you to a few cases which operate against them, but they are helpful. They have helpfully pointed you to these cases. So, first is Gypsy and Chaitan, Your Honor. And that, Your Honor, was run by Mr. Mendes and myself in Chaitan. I think it was run in that case. Okay. Now, if you look at page 281 of the case in the West Indian report, Your Honor, quickly to B. Are you with me, Your Honor? Thank you. Prematurity. Yes. 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 With that aspect of it, yes. Yes, Your Honor. One 33. Yes. I'm sorry, Your Honor. I thought that I had, when I said that 177 speaks only and creates a jurisdiction only in respect of the president. And 177, insofar as it speaks to the validity of an election of a president or the interpretation of this constitution, is to be read in respect of the interpretation of this chapter insofar as it impacts on the election of the president. What I say in answer to their question on prematurity. Milady, is it that you don't wish to hear me? With respect to the lack of...
I was asking about 133, but how do we reconcile the two?
I'm obliged. But the jurisdiction in 1.7 is exclusive and it is limited to the president. Now, Your Honor, many friends argue that the court also lacks jurisdiction because what is before you is in substance an article which should be brought under section Article 163 of the Constitution. Now, our answer with respect to that is that 177 of the Constitution speaks to the election of the president. 163, an application under 163, speaks to the National Assembly. We're asking the court in the same way that this court would move, and in the context of the dicta that I cited before, in re-USICA's application to determine a very narrow question of upon which turns the question, who is to be the president of Guyana? Now, Your Honor, if you look with me 77 2B of the Constitution, just over the section says where there are two or more presidential candidates, if more votes are cast in favor of the list in which a person is designated as presidential candidate than in favor of any other list, it goes on, that presidential candidate shall be deemed to be elected as president. That we're asking the court whether those words mean more valid votes cast. Now, Your Honor, it is a function of GCOM to declare by the chairman of the Elections Commission, and this is in the same 177 2B, to declare by the chairman of the Elections Commission, and these words are important, acting only in advice of the Chief Elections Officer. Who has more votes. Now, Your Honor, in interpreting the functions of GCOM, one must look at Article 162 the Constitution and 160. Are you with me, Your Honor?
Yes, I'm following you, Mr. Jeremy. We're following you.
Okay. So, Article 162 states, and the language again is mandatory. Elections Commission shall have such functions connected with or related to the registration of elections or the conduct of elections are conferred upon it by or under this Constitution or subject thereto, the Act of Parliament, and subject to the provisions of this Constitution, the Commission shall do various things. Now, one of the acts that Parliament has passed, Act number 15 of 2000, the Election Law Amendment Act. Another is the Representation of Acts. And both acts, we see, are relevant to the how GCOM has exercised its functions. The power to declare, subject to Section 96(1) of the Representation, is expressed to be a power which is primarily resident in the Chief Elections Officer. 96(1) says the Chief Officer shall, after calculating the total number of valid votes and I pause for emphasis, Your Honor. So those words, valid votes, are to be found at Section 96, representation of the People's Act. Now, the chairman must act in accordance with the advice of the Chief Elections Officer. That's at 177(2) of the Constitution. And I'm sorry to have you skipping between the legislation. But are you with me on 177(2)? It's the section that we were reading a minute ago.
Yes, we're with you, Mr. Jeremy.
So the president, it provides, yes, after B, it provides the presidential candidate shall be deemed to be elected as president, shall be so declared by the chairman of the Elections Commission, and these words are critical. The Supreme Law is provided that the chairman of the Elections Commission must act only in accordance with the advice of the Chief Elections Officer. Now, the next question, the question that logically follows is how do we get to a Section 96 report? Well, in the Representation of People's Act, Section 83, states that the presiding officer must do. I wouldn't elaborate on those matters. They are set out as paragraph 51 of our further written submission, but they include count the number of spoiled and tendered ballots, count the used ballots, count the unused ballots, and so on and so forth. But Honor, GCOM has wide plenary powers that have been recognized both in this and in the Ulisa War matter and in the case of Mohinda, which is an Indian case that I'll come to in a while. So GCOM, on our facts, has acted pursuant to Section 2 of the election law. And that section empowers GCOM. The side note is removal of difficulties. It empowers GCOM if any difficulty arises in connection with the application of this act. I'm sorry, are you with me, Your Honor? On Section 22 of the election laws.
We are following you, Mr. Jeremy. Please go ahead.
Okay. I'm obliged, Your Honor. So that Section 22 empowers GCOM if any difficulties in connection with the application of this act, the Representation of the People's Act, that's the Act that we looked at a while ago, National Registration Act, or any relevant subsidiary legislation, the Commission shall, by order, make any provision, including the amendment of the said legislation, that appears to the Commission to be necessary for its expedient for removing the difficulty. And any such order may modify any of the said legislation in respect of any particular matter or so far as may appear to the Commission to be necessary or expedient for removing the difficulty. Now say that when GCOM exercises its powers and Gazette 60 of 2020, by necessary implication, it amended it amended provisions in the Appeals Act, and that is insofar as the count is concerned, so that the count is now by linked to the validity of the vote stats. If you just quickly look at me at the recitals, the eighth recital, Your Honor, provides that it is of the authority vested in it under Article 162 of the Constitution and pursuant to Section 22, which we looked at, we seek to remove difficulties connected with the application of the RPA in implementing decisions related to the conduct of the recount. And they set out a procedure which is far more extensive than that contained in Section 83 and Part 9 of the Representation of the People's Act. So that ballots, because their purpose in promulgating 60 of 2020, as described in Recital 2, Recital 3.
Mr. Jeremy, you have another 5 minutes. Oh, are you going?
Yeah, thank you, Your Honor. I'll try to stop.
Well, finish your point.
On the
How you can
so,
wrap up.
in the third recital, the Chicago expresses itself as follows: as a means of assuaging the contesting parties and determining the final credit, we do these things. And those things include the reconciliation of ballots, issued ballot cards, destroys postal stamps as necessary account for postal stamps authenticity. No, Your Honor, that is far more extensive than anything that is contained in Part 9 of the RPA. So we see that having its purpose as being the establishment of credibility and having determined the term by which that credibility is to be achieved, GCOM must act as it's required to act, subject to acts of Parliament, and the order which they have enacted and which amends by necessification, as Section 22 allows them to, the provisions of the RP. And so that we say that when the Constitution speaks of more votes cast, it means more valid and credible votes cast who has voted once. And that is inherent in the order which GCOM has itself made. Now, Your Honor, we are not asking this court to do what an election court does, and where GCOM fell into error. We are not asking the court to consider any facts to witnesses. We are asking the court merely to interpret the provisions of the Constitution and the law. The Constitution refers in empowering GCOM to the general law. And we're asking the court to take note of the powers which is similar Science Commission exercised in the Mohinder Gill case. In that case, where the commission has a sufficient bona fide base to do so, it can invalidate votes. That is what the Chief Elections Officer has done, and that is what he is now being asked not to do. Your Honor, my learned friend said,
The case that you just mentioned.
Mohinder Singh, no, it is at paragraph 49 of our further submission by this, I believe it was this morning. I'm sorry if it hasn't got to you.
Could you please give us the name quickly?
But we received Mr. Mendes' submissions. Mohinder Singh and another versus the Chief Elections Officer and others.
Thank you.
Now, just in closing, Your Honor, my friends distinguish that case, which they must, by saying that it is a different mission. But in truth and in fact, the Indian courts acted under the provisions of the Indian Constitution, which at Article 324 is in pari materia with Article 162 of the Guyanese Constitution. There is no reference in that case to anything but the Constitution. And, Your Honor, we ask for the relief that we seek. We ask you to determine that, and it is almost counterintuitive, that we ask you to determine that when it comes to the president, you have authority under Section 177(4), and that more votes cast means more valid and credible votes cast by a voter who has voted once. Your Honor, that is all that I propose to say. I have half an hour. I would just ask you to look at the submissions which we filed late this month, in respect of which we elaborated.
In addition to what you have just put forward. Thank you, Mr. Chairman.
Maybe if I could just add just one more point. And my juniors are calling me and they will shut up as yet. If I don't make this
Yes, we're hearing you.
one point. Arthuri is an appellate, yes. Your Honor, my juniors are prompting me to say that Act 33, which we looked at, is an appellate jurisdiction, and of course, 177, original jurisdiction. I thought that I had made that clear, but perhaps I did not. My juniors, as I said, are prompted. Your Honor.
Okay, thank you, Mr. Jeremy. We've noted what you said. So, Ms. Kite?
Yes, please, Your Honor. Your Honor, we wish to rely on our written submissions. Honor, having read for Your Honors. Your Honors, we wish to rely on submissions. Having read my learned friend's written response and his very skillful attempt this morning to place his case on the 177 court. Your Honor, submission that in reality, when my learned friend's case is realized, when you consider the affidavit in support of the notice of motion, and even the arguments, when you really look at the substance, Your Honor, it is an attempt for this court to actually interpret a subsidiary legislation in the form of what is commonly called the Become Order, the amendment of the Become Order. And respectfully, Your Honor, we say that this cannot be brought within 177.4. Your Honor, the plain words of 177, the more votes cast, does not require interpretation. What my learned friends want this court to do is to interpret the Become Order to determine our valid votes. And when you look at the entire contention, Your Honor, the affidavit and even the argument, actually, this is what my friends are seeking. For honest, we are saying that this court, in the narrow jurisdiction granted to it under 170, does not have the jurisdiction to do that, to interpret subsidiary pieces of legislation. We also say, and we maintain, Your Honor, that the application is premature, as President Granger is still the sitting president. This application seeks the election of Dr. Ali. Dr. Ali has not been elected as president yet. So on that basis, Your Honor, we believe that is also premature. The second point, the second which we wish to make, Your Honor, is that the Indian cases relied on by my learned, especially the Singh case, Mahinder Singh bill, and another, and the Chief Election Commission. Your Honor, respectfully, that case has to be distinguished from our local circumstances. The Indian system has provided their election commission with additional powers, which include, Your Honor, the power to annul. Our circumstances here in Guyana, our commission has not been granted those powers by Parliament. Instead, Your Honor, what the Constitution has done, the Constitution has vested those powers was within the High Court, the election court. So that, Your Honors, this case cannot just our local circumstances, the best GCOM, with powers which Parliament did not see fit to the best in GCOM, the up to annul election. Instead, Your Honors, Parliament, by virtue of Article 163, and then provided for the High Court to determine questions of validity and credibility. And then our electoral framework set out clearly the mechanism through which this must be done. So let's ask GCOM to arrogate, and I want to make one last point. The action through the repump order to take away the jurisdiction of the to place it in the arms of GCOM. Your Honor, that is an impossibility and cannot be done through a subsidiary legislation. Our Constitution has outlined clearly how the Constitution can be amended, and it is not through a subsidiary legislation. You have to make Your Honor, is the fact that the system, the electoral system in India, from our electoral system here, they have to first pass the post, we have proportional representation. It means, Your Honor, they have constituencies, and it is that in which the polling stations, that their election commission can announce the election of a constituency. So the framework is different. The hours given to the election commission are also different, Your Honor. And so, Your Honor's respect for the nothing, the industry can apply to our local situation. I have at length, Your Honor, outlined all these, every single point I've made. I do not wish to waste the court's time by simply regurgitating what I already heard. So I prefer to, unless the court has anything else to inquire of me, it's really what we wish to say orally. Because respectfully, Your Honor, we have taken the time to outline these points in our written submission. So I said earlier, having read my learned friend's response to those submissions and his presentation this morning, we are in no way removed from what we have placed before the court in writing. So unless I could assist the court forward further, Your Honor, that would be oral submission.
Mr. Thomas?
Hello?
Having regard to the fact that the come forward just the order, defined as its objective, the final credible count, determining the final credible count. A short question would be for you to say, person in whom that responsibility resided, and secondly, how was that responsibility to be discharged?
Your Honor, we have examined that recount order, and I say the court has to determine credibility, not GCOM. You see, Your Honor, it goes back to my point, which relates to Article 8 of our Constitution, and also that in my written submission, that a subsidiary legislation cannot amend the Constitution Constitution, which says which must determine credibility and validity. So it is the court, it is still the court. The recount or the Panama Constitution of the Cooperative Republic of Ghana, which is the supreme law of the land.
But you do agree that the order did set as an objective of the commission determining the final credible count.
The order, yes, please. The order did say that. And that is why I'm saying that the trust of my friends are arguments is an interpretation, not really the interpretation of the Constitution. And for that, Your Honor, again I say they need to return to the High Court for that. Because you are looking at an interpretation of an order and not the Constitution. The Constitution remains the supreme law of the land. And any ordinary legislation cannot amend it unless it is done properly. And the Constitution itself outlines how it can be amended. And we say, we emphasize, it cannot be true, then it becomes the order.
Thank you.
Thank you, Mr. White. Mr. Williams?
Well,
As a please, Your Honor. Hold on. That's the big one. Every bear with me, Your Honor. We're trying for the big one. Much obliged, Your Honor. Is the video on? The video is not on.
We're hearing you, Mr. Williams, but we're not seeing you. But please go ahead.
Just having some I have a technician here getting technical difficulties.
But we're hearing you, so please proceed.
I understand that the host has stopped the video. So we have it now. Thank you, Your Honor. Very quickly in terms of my time limit, let me say that I concur with the submissions of the applicant, especially in relation to jurisdiction, to say that the 30 in relation to Article 177.4, that was dealt with in our court, UC Guyana, and specifically at 135, it shows clearly that it is read disjunctively, so that it's not only in relation to election matters, and this is what the court said. Let me now turn for argument's sake to assume that this court is empowered to determine the matter. By Article 177.4, for this court's jurisdiction must be levels that are specified in Article 177.4. The issues that can be properly dealt with are the qualification of the president or interpretation of the Constitution. An examination of the supporting affidavit to the motion does not disclose either of the two issues specified in 7.4. So the court is very clear that there are two separate issues or the interpretation of the Constitution is not restricted to the qualification of a person for president. And if I might respect before you quickly, so the interpretation of Chapter 201 or in the definition section is defined as order and otherwise construed disjunctively, and not as implying similarity unless the expression similar or some equivalent expression is added. There are two separate issues there. You all mentioned Article 133 and 90 in addition, and might I respectfully refer you to the case of Sesimo Guri. And that case really is where all provisions of the Constitution touching on an issue are considered together, and the Constitution must be looked at as a whole. So that we have to look at all of, and in Makiwan, our own Makiwan case went to the CCJ, it says very clearly, the Constitution is to be construed as a whole, and courts are to adopt a broad, generous, and purposive approach in order to give the concepts on which the Constitution was founded. So, Your Honors, it's for the states in the same Oguri case, Washington Attorney General 2005 1 report of opinion, that there's a cardinal rule in Constitution that provisions of a Constitution concerned with the same subject should as much as possible be construed as complementing and not contradicting one another. The Constitution must be read as a and cohesive whole. So, Your Honor, the Constitution of this court is well founded. But even more so with the fact that there's an absence of rules. And the former Chief Justice of the Sixth, Michael Gilbert himself, and Vincent Peters, an Attorney General, and the same Chaitan, an Attorney General that is referred to, Nelson J.A., they say that in the absence of rules made under the representation of the People's Act, such applications should be made in accordance with the rules of the Supreme Court, and in this particular case, the Court of Appeal. So, Your Honor, I would like to leave those. And of course, remember about John Doe case. If there's no procedure fix, we can't hold our hands. Your Honor, I'd like to move on quickly, and I would like to address. First of all, could I ask that at page 5, issue 3, that any reference to Article 161 be expunged? So wherever it occurs, it's also on page 7 with issue 3. Your Honor, the question, what upon the true interpretation of Article 162 of the Constitution and the recount order, or the 6th of 10, the Divine Elections Commission has a duty and responsibility to determine whether the 2020 general and regional elections were fair and credible. Your Honor, we are contending that notwithstanding at paragraph 5 said that it could not have clothed itself to the jurisdiction as a court of law to determine credibility of an election, etc. We say, Your Honor, what GCOM did. GCOM, in its order 60 of 2020 wants to go on deep to resolve difficulties and to get to a free, fair, and impartial election, made provisions in this order number 60 of 2020 that was gazetted the jurisdiction to deal with credibility. And the honors have recognized that this is not a situation where elections are, the results have been declared, and we are in a post-election stage. We haven't reached only the order that was made, we are at stage 3. So the relevant powers that itself in here in these provisions in Order 60 of 2020. 1. Recital. Whereas the President and the leader of the opposition and all contesting parties agree to a current proposal for a electoral districts as a means of persuading the contesting parties and determining the final recount. So that tells you clearly GCOM is imposed on the order to determine the question of credibility. As recital is even more empowering, where it says that they are to remove difficulty and they must do a reconciliation of all ballot issues with the ballots cast, destroyed, spoiled, stamped, and as the necessary to stops authenticity of the ballot and the number of votes listed and crossed out as having voted, the number of votes cast without no proxies issued, and the number utilized statistical anomalies of occurrences recorded in the poll book. Guys, these are the powers that GCOM gave itself. These are the powers that GCOM gave itself to do. That's the credibility of the elections of March the 2nd. Let's go on. Paragraph 6. Paragraph 6 is the paragraph that created the observation report form. And in this observation, you are the workstations, they were to report and record all of those occurrences that occurred outside of the ballot count. And that's where all the irregularities, anomalies, and discrepancies were reported. Going further, at paragraph 12, the order says what you would do, additional report forms. The matrices for the recount of 10 electoral districts shall then be tabulated by the chief election officer and shall be a report together with a summary of the observation reports for each district for the commission. So then present the observation report. So essentially, Your Honors, the process was that whatever the in the polling station, even at that low level, the return trained to apply these rules, and it doesn't need a code to determine. You need a poll book. So that poll book tells you it's not a question for court, it's a question for the officials of G. To resolve. And of course, paragraph 14 tells you what the commission must do and the addendum. Right quickly that Commission shall after deliberating on the report in paragraph 12 that was sent to it by the CEO, must do. So it has a discretion to determine whether it should request the chief election officer to use the data compiled in accordance with as the basis for the submission of a report under section 96 of the rule. That is they had a discretion. And the report they received from the CEO at the third stage, in every district he summarized, he said he couldn't ascertain the results of the elections from the votes and the information supplied on the recount because they didn't lend themselves to credibility. He said that very clearly. So what was the commission to do when they were in receipt? CEO's report. They too had a duty to deploy the credibility test to the ballot count. But they didn't do it. They didn't do it. Because if they had done it, they would have been constrained to accept the report of the that the elections were attended by a lack of credibility. And follow-up elections, they had the duty to do that because they are responsible for the elections, the conduct of the elections until up to the moment of the results of the elections. We haven't gone there yet. So they're well equipped. And I could move issue whether for a true interpretation of Article 162 or the 6th of 2020, whether the GCOM doesn't have an inherent or implied jurisdiction to cancel the 2020 elections and inform the president of such cancellation. That is the issue. GCOM cannot make an order and then resile from it. GCOM has to stay the course so that you have all these orders as to in the observation report, etc. And when it reaches the commission, they don't apply it. They don't apply it. So let's look at the release they said at paragraph 6. It was said that the commission can not arrogate onto itself the Justice Day press release. It's an exhibit in the applicant's case. The commission cannot arrogate onto itself to annul an election since no specific power was conferred on it under Article 162(1)(b). And that is the exact case that we are dealing with, Your Honor. The exact case. Because saying it is a quasi-judicial body, the GCOM. And they have to specifically say that if there are no rules, if there's nothing, the legislation for the commission to invoke, what are they to do? They are a high functionary body. What are they to do, Your Honor? Well, the angels are very clear, and I'm surprised that at this point in time, a jurisdiction in which the inch predominates, where our courts have long had recourse to the decisions of those brilliant jurists, full legal minds. I don't understand at this 11th hour why we want to debunk them now. So let me straight what I'm saying about those beautiful minds. In the case of J. Shankar Patel versus the Election Commission, number 1801 of Chapter 12 is listed there on the list. There was the same situation. In the case, the Elections Commission in cancelling the entire process of the election on the allegation of the use of money and horse trading and uncertain submitted by 3 voters during the process of casting a vote. I don't wonder whether they were in the booth there with a phone, a cell phone, they came to just to show how they voted. As recommended for cancelling of the election process itself, they contended that the election commission was wholly without jurisdiction, and so they went to court. So we're making this point. That commission felt that with all the fraud and chicanery, that they couldn't allow the elections to go forward. And that's the similar situation that this election commission is in. And I would shudder to think that the Guyanese people should countenance that in the face of overwhelming clerical use, irregularities, discrepancies, anomalies, that anyone would be wanting to be ushered into on the basis of that type of flawed, illegal, despicable acts of trying to destroy the result of the election. Welcome to into office under such a cloud. And how could a commission say it's powerless? So what are we going to do? We accept that you have these things and then say powerless to cure it. And these cases say you have an intent to do what is right. And so let me read the paragraphs 26 and 27. What that court said. Opinion, the Election Commission did what the Honorable Supreme Court expects from high functionary authority, like Election Commission, that even if the law and the rules are absent, I repeat, Press really said that the Commission said they didn't have any rule already. But even if the law and the rules are absent, even then, if it comes across such a situation, then they have to tackle that situation. So it should not remain with folded, listen carefully, John. The election commissioner should not remain with folded hands and pray to God, divine inspiration, to enable him to exercise his functions and to perform his duty, or to look at any extent of the grant of powers to deal with the situations. In these cases, we are of the considered opinion that has acted befitting its office by taking extraordinary steps of stopping the content promptly after the result of the poll, and forthwith recommended for rescinding the election notifications of Her Excellency the President. That country was not prepared to countenance any unlawful activity. Must is in a situation of such an election. And the contention is made by my learned friend that their system different, that was just a constituency. But the rules are applicable. Ghana, under the PR system, is one constituency. So there's no difference, one constituency. So the rule applies, whether it's a single constituency or not. Because what they were not to say is that things are the very foundation of democratic institutions. And they refer to the case of Rokavi, Belagali, and Jack. They said, and I quote, free and fair elections are the very foundation of democratic institutions. And just as it is said that justice must not, but must also seem to be done. Similarly, elections should not only be fairly and properly held, but seem to be so conducted as to inspire confidence in the mind of the electors that everything has aboard and has been done to ensure free elections. So, Your Honor, this case shows you that when you're functioning with such high authority like the Elections Commission, can't say alas, not middle of, and that's the end of the matter. So the doctrine to pass all other unlawful conduct and activities. And Your Honor, I report to the Moyenderson case that also says it. And I'm saying also that Article 324.1 is also empowering material that 1B says this. But after the President's notification has been issued, the electoral process is in the charge of the Election Commission, as here. And the Commission is exclusively responsible for the conduct of the election without private agency. We do not find any limitation in Article 324 on which it can be held that a law made on the article or the relevant rules made thereon do not provide for the mechanism of dealing with a certain extraordinary situation that has of the Election Commission, and it cannot independently decide for itself what to do in a matter relating to an election. We are clearly of an opinion that the Election Commission is competent in an appropriate case to order a report of an entire constituency when necessary. It will be an exercise of power within the ambit of its functions under Article 324. The submission that there is complete lack of power to make the impugn order on Article 324 is devoid of substance. So the Ghana Elections Commission under Article 162.1b, where they are required to do whatever they could do to ensure we have free, fair, credible, and impartial elections, have that power, and they can't hold their hands. So, Your Honor, we continue relying on these cases so that at the stage 3 exercise, the Commission failed to address the issue of credibility in the light of all irregularities, discrepancies, and anomalies, especially highlighted in the report of the Chief Elections Officer. And let me say this about the Chief Election Officer. The Chief Elections Officer has a secretariat, he has all the staff, etc. He is the workman. His work is the basis upon which the Commission is advised. And the Commission really should be slow to not to accept the advice of its Chief Election Officer. In fact, in relation to 177, the election of the President, 177.2, when the CEO's report advice to the Commission is the only advice the Commission could want, and they have to take it after it. And it's not for sure, there has been no declaration of results here. There's no question of Article 163 kicking in. Article 163 only kicks in when there is a declaration of the results of the election. So right now, we have a situation where we have all these discrepancies, anomalies, etc. And we have the Malawian case. Malawian case shows clearly it imposes a duty on the Commission that if contesting parties raise allegations of irregularities, discrepancies, or anomalies, before they declare the results of the election, they have a duty to resolve those complaints, even to hold an audit. That's what the Malawian authority says. And somebody said that doesn't apply here because that was a decision given in an election petition, but I don't know. I thought that it's a principle that we have to use when a court makes a decision. We don't have to go back to an election petition to apply, so we apply that principle. And in any event, Indiana itself, in the no confidence motion, when we were dealing with the question of dual citizenship, we were all astounded. 4 years after the elections had been determined, that one was required to go back to say that you ought to have brought your complaint during the period allocated after the results of the elections are declared. So that it can't be that because in the Malarian case an election petition, it was determined on an election petition that that's what should be done. It means that elections commission must take advice. But the Indian courts have it. You come over to Africa, they have it. That you can't hold your hand in the face of serious irregularities in an election that you have control and conduct of. And allow someone to be elected on that platform. And we're saying that it ought not to happen here in Guyana also. So, Your Honors, I don't know if my half an hour is up. I have to be guided. Yes, please, Your Honor. In light of the foregoing, it is respectfully submitted that the Guyana Elections Commission, in the execution of their duties to ensure free and fair elections that yield results that are a true reflection of the will of the people, may exercise the power to cancel the elections in the face of anomalies, irregularities, and discrepancies. To ignore evidence of corruption and proceed with a declaration would be to undermine the integrity of the Commission and erode public confidence in the electoral process. When confronted with such extraordinary circumstances, the Guyana Elections Commission ought to exercise its jurisdiction and declare that the general and regional elections held on March the 2nd, 2020 are cancelled, and so inform the President. I thank you, Your Honor.
Thank you, Mr. Williams. So, as we indicated, we will now take an adjournment for 50 minutes, and we will begin with the arguments of the other respondents at that time.
Thank you, Lionel.
Yes, I'm advised that the resumption time will be 12:50, which is 10 to 1. So that's the time we'll be convening. So thank you very much.
Good night.